Well, welcome everyone, and thank you so much for joining me. My name is Lior Samfiru. I am the employment lawyer, and welcome to your employment law session. This is the time, the place, the opportunity to learn about your employment law rights, your workplace rights. That's why I'm here for, to make sure you have more knowledge, that you are armed with information about this very, very important topic, employment law. So again, I'm Lior Samfiru. I am one of the founding partners of Samfiru Tumarkin LLP. My firm, we practice employment law and disability law across Ontario, British Columbia, and Alberta. So if you're in one of those provinces and you have questions about employment law, you are in the right place at the right time. So if you have a question, ask it. You can get some answers, you can get some information, you can feel better about your rights. It's okay to ask, what can the law do for me? Because chances are it can do quite a bit. And on this session, every week, I'm on here telling you what the law is, whether you're in a bad working relationship with your boss, you're being mistreated, maybe your job has been changed, your hours, your compensation, your responsibilities. Maybe you're losing your job or lost your job. I speak with people every single day that have lost their jobs to make sure that that termination is legal, that you get what you are owed. So if you have a question about anything like that or anything at all having to do with your workplace, ask the question right now. You can get the information that you need to make sure that you're not being taken advantage of, that you're able to stand up for yourself. Now, beyond this 30-minute session, to connect with me and my team, so very easy to do. All you have to do is go to employmentlawyer.ca, again, employmentlawyer.ca, and when you go there, you can find out so much more about your employment law rights. You can contact me. You have the phone numbers there, email addresses there, all the tools you need to reach out to myself and my team across Ontario, BC, and Alberta. They're all there. But right now, I am live, and I want to get your questions. Questions have just come in, so I'm going to start answering them. You have time right now to think about your question, to type it in, to hit enter. I'll see it, I'll read it, and I'll answer it. It's quite that simple. Nothing is simpler than that. So again, I'm Lior Samfiru, the employment lawyer. Welcome to your employment law session. Let's get some questions answered. Ask yours as well. Okay, our first question comes to you asked to us from YouTube, from Sir. I was wrongfully dismissed without full severance. I was promised I'd be rehired once the company recovered financially. Instead, they gave me my position to someone else. Is this legal? So it is not illegal to give your position to someone else. If you're in a non-union position, the company can simply decide to let you go. So it's unfair and it's wrong, but from a legal standpoint, the company can say, instead of bringing you back, I'm going to hire someone else. That's not a nice thing at all to do, but legally they can, as long, this is the key, as long as they pay proper severance. So what you're owed here is full severance. Now, sir, I don't know how long you've been there, the job you had, etc. But if you've been there long enough or you're old enough, you could be owed as much as 2 years pay, as much as 2 years severance. So the key here is to go over what you've been offered and make sure you're owed, make sure that you're not owed anymore. Chances are, this is true for sir, this is true for anyone. If you've been let go, whatever the company's offering you, chances are it's a lot less than what you are owed. Okay, it's rare for me to speak to someone that's been offered properly, that's been offered what they're owed. So, sir, you're probably owed much more. What makes it a wrongful dismissal is if you have not been paid your full proper severance. So the next step, very easy. You connect with me and my team, so easy to do, through employmentlawyer.ca. Again, employmentlawyer.ca. We can have a private conversation. I can find out more about you, your job, what they've offered you, and help you get what you are owed. So thank you for that question, sir. Great question. More questions coming in. Love it, love it, love it. So I'm going to continue answering right now as well. If you've just joined, though, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. I'm here live taking your questions about employment law, about workplace rights. Ask your question. Don't just listen. Listening is great. You'll learn a lot. But it's even better if you ask your question so I can solve your problem. All right. Next question, continuing. The Duddy fam. The Duddy fam have a question. I've been on paid suspension since April 19th. I spoke with your office when it happened, and they told me, wait and see, but I have not heard a single word from my employer since that date. Okay, so have you followed up with the company? Because I want to understand what's the suspension for. Obviously, I don't have all the information. For example, if they're investigating something in the workplace, well, we may need to wait for them to conclude that investigation. If this was an unpaid suspension, it will be illegal. That will be already a constructive dismissal. Because it's paid, the company has a bit more leeway. That said, if you were to follow up with the company and say, hey, company, what's going on, when I can come back to work? If they ignore you, maybe do 1 or 2 follow-ups. If they ignore you, that could already be a constructive dismissal, okay? It could be very embarrassing to be off work like that, but I'd want you to follow up with them. If you haven't, do it. If you followed up and they've ignored you, it's time to say constructive dismissal. You can call us. We'll schedule an appointment to go over it. A constructive dismissal happens when, based on how the company has treated you, you may be able to consider that as a termination and force them to pay you your full severance. So that's what's here. This matter is about. But I want you to follow up in writing, text or email, saying, I've been off since the 19th of April. What's going on? When can I get back to work? Let's see what they say. Hopefully that makes sense. Any follow-up questions, I'm still here. Ask them or contact us after you followed up with the company. All right, let's see. Continuing to answer questions, by the way, with me, Lior Samfiru, the employment lawyer. I'm going to continue answering. Ask your question now, just like so many people are. Ask it, ask it, ask it. Mailman has a question. Maybe you're a fan of Karl Malone. In any case, Mailman has a question. My employer has temporarily taken away our extended health benefits, which is stated in our employment contracts. Our extended health benefits quite generous, including life and accidental death. Could this be treated as a constructive dismissal? So if your employer completely took away your benefits, yes, that could be a constructive dismissal. It's obviously a significant portion of your compensation, of your terms of employment. If they took some benefits, it may not be a constructive dismissal, okay? So if all of them are gone, potentially, absolutely, they could be a constructive dismissal. Remember, your employer does not have a right to make significant changes to the terms of employment. And completely taking away all your benefits is a significant change. So you may be able to say constructive dismissal. That means that, no, I'm not accepting this employer because you've taken away all my benefits. I'm going to consider that to be a termination. Now you, employer, have to pay me my severance. Now, Mailman, if you want to consider this a constructive dismissal, if you want to pursue a constructive dismissal, before you do anything, before you say anything to the company, you call us, okay? We have to do this right. I want to find out more about you, about the company, about what they said to you about the benefits, etc. So the first step is to connect with us off air, and to connect with us, very easy to do, employmentlawyer.ca. Again, employmentlawyer.ca. So thank you for that question. Great question. I'm still here if you have a follow-up. All right. Thank you again for joining us. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm live answering your questions. You see a little box there on the screen. Type in your question, hit enter. You have time. I'll read it and I'll answer it. All right. Next question comes to us from Nigel. I've been a remote consultant for 4 years for a company that just laid off 1,000 people. Though I wasn't impacted, my projects are on hold and my workload, including my 2024 purchase orders, have been cut. I have strong evidence of misclassification. Should I exit now or wait for the contract to end? I'm worried waiting may reduce severance, because my pay is being reduced. So the first question is really, are you an employee or are you a contractor? So I don't have all the information, but if you've been there working just for them for 4 years, chances are you are an employee. And that, as you say, you've been misclassified as a contractor. And this happens very often. Many people believe they're actually contractors, but no, they're actually employee. Remember, if you look like an employee and act like an employee, you're an employee. Doesn't matter what you sign, doesn't matter how you pay your taxes, doesn't matter if you charge HST. If you look like an employee, if you have a regular job, then the law will consider you to be an employee. Now, for you, what this means, Nigel, is if you are an employee, they can't do what they're doing. They can't change your compensation or take away work from you. That, again, would be a constructive dismissal. So let's talk about it. Before you do anything, I want to find out more about you, about the company, about your history there, about how your compensation has changed or has not changed over the years. And on that basis, I can assess if this is a constructive dismissal and the best way to pursue it. So hopefully that makes sense, Nigel. You can connect with me through employmentlawyer.ca. The address is on the screen right there, employmentlawyer.ca. All right, continuing with questions. Manowar has our next question. If you sign a release after termination, is there no going back for extra severance? That is correct. That's why I say you do not sign anything when you're let go until we speak. Because what the release does is it's a legal document that says, by signing this, I agree that I'm not owed anything. I agree that you've paid me everything that I'm owed and that I will never, ever ask for anything more. That's what a release does. So you cannot ever sign that until we've spoken, until we know you've gotten everything that you're owed. Now, obviously, Manowar, I don't know anything about your situation, but I can tell you just from a statistics standpoint, there's a 90+% chance that whatever you accepted is less than what you're owed, probably a lot less. But the bad news is you're stuck with it. Every single week, people contact me wanting to know if I can help them after they've already signed that release, after they signed those severance papers. I can't, unfortunately. No one can. So what's the key here? If you lose your job, you call me. We do this properly. We get you what you are owed. So unfortunately, Manowar, it's bad news, but there's a lesson there, an important lesson for everyone watching this session today. So thank you for that. Great questions coming in today, guys. Fantastic. So again, if you've just joined us, ask your question with me, Lior Samfiru, the employment lawyer. I'm here with you, for you, making sure that you have all the information you need about workplace rights. If you want to know something, ask. I'll tell you. All right. Next question comes from Daniel. My friend worked for 25 years for a company and was given nothing. He was moving out of province and gave 3 months notice. They asked him to commute from Quebec to Oshawa for months to train a new guy for his position. They paid him for travel and hotel expenses. He just walked away in the end. Does he have any rights? They wouldn't fire him. So this question is a bit confusing. I'm not sure if I understand all the facts here. He gave him 3 months notice. Did he leave at the end of the 3 months? Did he stay longer than 3 months? So I would need some more information, Daniel. So perhaps you can reach out to me off air through employmentlawyer.ca so we can have a chat. Thank you for that, Daniel. All right. Next question comes from, from Fabrizio. Who should provide me with the disability policy? I asked my case manager, and he told me that he will request to customer service, and then he'll let me know. Is that correct? Well, I don't know what their policies are, internal practices, but someone from the insurance company is going to be able to give that to you. You just need to follow up with them. Every insurer is different, but yes, that won't be a problem. I've never had anyone tell me that they can't get a copy of their policy. Let's see. Okay, so Nigel, you asked the question again. I think I answered about the misclassification. Hopefully that makes sense. Let me know if there's a follow-up question. Next question comes to us from Mary. Mary's joining us on Facebook. I went to Mexico with my supervisor. She got drunk and became aggressive, so I left and had to find my own way back to Canada because she kept my itinerary to return. I spoke with my boss above her, and they didn't help, so I resigned from my position. Now the agency won't call me for my casual position at other locations. Should I just submit resignation from my casual position because I haven't been called for months? No, you shouldn't do anything until we speak. So first of all, you may be owed severance if you were put in this very difficult situation, the company did nothing about it. That could be a constructive dismissal, but I'd want to find out more. Okay, so I'd want to understand in terms of the difference between the two roles, who you were working for how long, but you may well be owed several months of compensation in this situation. If you can prove what happened when you were away, and that the company didn't do anything to help you, that they didn't try to put in place mechanisms to ensure you're safe, etc. Company has a very strict legal obligation to keep you safe, to support you, to make sure you're not put in a dangerous situation. So sending you off to Mexico and not taking care of you could be a huge, huge problem. That could be a constructive dismissal. So I'd want to find out much, much more about you. Don't do anything. Okay, Mary? Don't resign. Don't do anything until you contact us. To do that, very easy to do. Employmentlawyer.ca. Again, employmentlawyer.ca to connect. And I look forward to doing that. All right. See how easy it is to ask questions, right? You still have time. Every week, I say this every week, and every week it happens, I get questions right at the end, just as I'm saying my goodbyes, then I don't get to answer the questions. Now you still have time. We're still here for another 15 minutes. Plenty of time. So ask your question right now. Make sure you get an answer, and you're not leaving disappointed at the end because I didn't get to it. So again, I'm Lior Samfiru. Ask your question here with me, the employment lawyer. Mary has our next question. I have been having a lot of stress at work for a while now. I have been in the same company for 8 years. Last week, my stress level escalated to the point that I am having health issues, and I have been home since Thursday. I visited my family doctor, and he gave me a letter for 1 month of stress leave. Is my current boss obligated to pay me for those days that I'm away? So no, your company does not have to pay you your salary for the days you are away. That said, there's several options for you to get paid. Number one is EI sick benefits. So if you can't work, that's why we have EI sick benefits. They can pay you as much as 55% of your income up to a certain amount. So there's that. You may also have a short-term disability plan. If you have a short-term disability plan, you can apply for those benefits. That can pay you even more. So you can apply for benefits through that plan. Depending on the situation, you may even be able to apply to workers' compensation. In other words, if your health reason comes from being at work, from something that happened at work, that may be covered under workers' compensation. You can get benefits from them. But no, your employer itself is not legally required to pay you while you're off. Now, you may have a certain number of sick days at work, so you can use those sick days. But once those paid sick days are used up, assuming you have them, your employer is not required to pay you while you're off sick. But there's several options for you to get paid. If your employer, when you're ready to come back to work, your employer should be taking you back to the same job, same everything. If they don't want to take you back, if they ignore you, if they want to give you a different job or different pay, you call me. Now, when you're ready to come back to work, your doctor may say you can come back to work, but you need some accommodation. Maybe you will need to work less hours to begin with, or maybe you need some modified duties. If that's what your doctor says, you need a note from a doctor saying that. Your employer then has to accommodate you. They have to. It's not up to them to say no. It's not up to them to decide. They have to do it. So get that doctor's note. Any problems, you know what to do. You connect with me and my team through employmentlawyer.ca. Again, employmentlawyer.ca. All right. Next question comes from AB1. Do you handle cases of employees who were refused by employer to take family medical leave? Generally speaking, we can handle it by simply sending a letter to the company saying you better give the person the leave or else. So that's an easy way to resolve it. Another way is to file a complaint with the Ministry of Labor. That can take longer. But yes, can we help? Sure, we can. Usually once the employer hears from us, they back off and they do what they're supposed to. So hopefully that makes sense, AB1. Any issues, you know what to do, employmentlawyer.ca. All right, I have more questions coming in. Let's get to them as well. But I know you're watching, I know you're listening, and I thank you for that. I'm grateful for that. But ask your question as well. Nick has our next question. Over 25 years, 30-week continuance, 39-week lump sum, i.e. 16 months. Asked for 24 months, they responded 18 months or 20 months with mitigation clawback. So, yeah, I mean, I don't know exactly the job you were doing, and I don't know how old you are, but you absolutely could be owed 24 months. But it's not really something that I would have expected you to just ask and get. Usually we need to get involved in that to make the company pay that. And once they hear from us, they'll, as I was saying earlier, they'll do what they have to do. So if you're trying to negotiate on your own, you're at a disadvantage. That's true for everyone. Like if you're, for example, 45 years old and you had an entry-level position, it may be that you're not owed more than 18 or 20 months. But if you're a bit older or had a more senior position, absolutely it could be 24 months. That's where you need to call us so we can properly assess it and get you what you're owed. Often a letter or two from my firm does everything you need it to and get you that compensation. So again, to connect with me and my team, Mick, easy, employmentlawyer.ca. employmentlawyer.ca. By the way, so I was talking with Mick about severance and how much severance he's owed. How does Mick know how much he's owed? How can you find out how much you're owed? Very easy to do. You can do that right now. You can simply go to pocketemploymentlawyer.ca. The address is right here on the screen, pocketemploymentlawyer.ca. And when you go there, you'll click on the severance calculator. That's it. Use the severance calculator at pocketemploymentlawyer.ca. You answer a few questions, and it's going to tell you how many months of severance you are legally owed. By the way, it's completely free. It's completely anonymous. No names, no phone numbers are needed. No email address is needed. It's just there for you. And you will be shocked by how much you're owed. So many people believe that they're owed a week per year of service or something like that, when in fact it's much, much more than that. You could be owed several months of severance, even if you've worked for a few months only. So you know what to do, employmentlawyer.ca to connect with me, or to use the severance calculator, pocketemploymentlawyer.ca. Check it out. You'll be surprised. All right, next question. Continuing to answer questions. You still have some time, guys. Still have a few minutes to go. You have time to get those questions. If you ask it now, I promise you I'll answer it. Khalid, do you deal with WCB? No, we deal in disputes between employees and employers. If you have a WCB matter, a workers' compensation matter, connect with me and I'll send you a referral to someone that can help you that deals with that. So again, you can connect with me through employmentlawyer.ca. But as a firm, we only deal in issues, disputes between employees and employers. Hopefully that makes sense, Khalid. All right. From Keith, next question. I am in Canada on an open work permit. I accepted a full-time position and have been working for the last few months. My employer is only paying me for part-time hours and keeps making excuses as to why I'm not being paid properly. I think I'm being discriminated against because I'm from a different country. Do I have any rights? So remember, the law does not define or distinguish between full-time and part-time. There's no definition of what part-time is or full-time is. The key is this, that for whatever hours you work, you should be making at least minimum wage. That's it. So if your employer pays you at least minimum wage, once you consider all the hours that you're working, they're doing it legally. So if you're making less than minimum wage, completely illegal. Okay, you can file and you should file a complaint with the Ministry of Labor. Okay, that's the way to go. If they're paying you minimum wage, even though you may have expected to make more, but they're paying you at least minimum wage, you haven't done anything wrong. So hopefully that makes sense. Keith, any issues, you can connect with me through employmentlawyer.ca. Okay, let's see. Next question from Kane. What rights do workers have if employers change their work location? For example, if offices are moved to a place a long way from the previous location. Excellent question. So if the change is going to impact you in a significant way, that could be a constructive dismissal. Now, what is a significant way? Generally speaking, if the change means that because of that change, it's now taking you an extra 1 hour to get to or from work, that is a big deal. So for example, if it used to take you 20 minutes to get to work, now it's an hour and 20 minutes, that's a big change. So that may be a constructive dismissal. So you can't physically stop your employer from moving locations, but what you may be able to do is consider that move to be a constructive dismissal, a termination, and to require the company to pay you severance. So that's what you do, okay? Employmentlawyer.ca to connect with me if it's a significant move. So it's not about the number of kilometers. A lot of people think, oh, this many kilometers or that kilometers. Completely irrelevant. It's about how it impacts you. They may have moved 100 kilometers, but it could end up being closer for you. So that may be a good thing. So that's not a constructive dismissal. Or they could have only moved 5 kilometers, but maybe you don't have a car and now it's going to take you forever to get to work. Again, that could be a constructive dismissal right there. So to connect with me, Kane, so we can discuss this. And if you want to pursue a constructive dismissal, employmentlawyer.ca. Again, employmentlawyer.ca. All right, Mick is giving me some more information. Mick has said that he'd worked for the company for 25 years. I'm almost 60 years old, reported to a VP. I'm an engineering professional. So yes, you'd be looking at 24 months, Mick. So that's what you're owed here. So less than that is not appropriate. So call us. Let us do what we do. A lot of people say, well, I'll just ask the company. No, they're not going to give you more just because you've asked. They'll give you more because they know now they don't have a choice. They know that you're doing something about it. So that's why you connect with us, Mick, and we help you. Again, employmentlawyer.ca. If you're already at 18 months or so, it shouldn't be hard to get you higher. So again, employmentlawyer.ca. All right, let's see. Maybe I have time for another question or so from Dawn P. I was let go from my position after 3 years. My employer is offering me 4 weeks of pay and have asked me to sign a separation agreement. Should I sign? I'm not sure I understand the point of the agreement if I'm just going to have to end up on EI. So no, because you're owed a lot more than 4 weeks. Now, I don't know exactly what your job was and how old you are, but you're probably going to be owed not 4 weeks, but probably 4 months or more than that. It could be 5, 6 months, no problem. So by signing this, you're essentially going to be agreeing that that's it, I'm good with 4 weeks. EI has nothing to do with it. EI is going to kick in after the severance runs out. But yeah, a lot of people think that, well, just because I worked somewhere for a short period of time, I worked for 3 years, I'm not owed much more. Not at all. Short service employees are treated disproportionately better than longer service employees. So you worked there for 3 years, could easily be 4, 5, 6 months. If you're in a very senior role, it can even be 12 months. So please don't sign that severance. You cannot sign that severance. You want to connect with me, and so we make sure you get what you're owed. Don't be one of those individuals. Unfortunately, we already had one today as well, who contacts me asking if I can get them out of the agreement that they've signed. I can't. No one can. So you have one opportunity only to do this right. So contact me, and let's make sure you get what you're owed. Again, employmentlawyer.ca. Last question from the day. This is from E. If I submit a resignation notice of 3 weeks and the employer asks that I leave sooner, am I entitled to 3 weeks pay? Yes, you are. You're entitled to your termination entitlements, whatever your severance is, or until whatever your last day was going to be, whichever is less. So yes, you would be entitled to the additional payment for that 3 weeks. So yeah, if they want you gone now, they can, but they still have to pay you. So if they don't, you know what to do. You contact me. Very easy to do, and we'll make sure you get that compensation. Guys, that's the time that I have for today. Some fantastic questions. I'm really glad that I had an opportunity to answer all these questions. You may think, oh my gosh, I missed the opportunity. I don't get to ask questions. Of course you do. You just can send me an email or you call me. You go to employmentlawyer.ca. All the contact information is there. Phone number, email address. If you prefer, you can fill out a form and we will call you. So easy to do. So just because I'm going to shut off my webcam here does not mean I'm going anywhere. It does not mean that this conversation is over. Contact me anytime through employmentlawyer.ca. Guys, I'll be back next week to answer more questions. Of course, my colleagues will be in as well before then, but don't wait until then. You need help. Get us to help you. Get us to help you now. Employmentlawyer.ca. Guys, I'm Lior Samfiru, the employment lawyer. This has always been a pleasure. Thank you so much for joining me. We'll talk to you all soon. Bye now.